In any American hospital room, a simple legal standard applies. If you are born on U.S. soil, you are automatically an American citizen. This historical document is the 14th Amendment. Ratified over a century ago, it serves as the constitutional bedrock for that specific protection. That century-old guarantee faced a direct challenge on January 20, 2025, when President Donald Trump signed a new executive order at the start of his second term. His directive sought to end automatic citizenship for babies born to undocumented immigrants or parents holding temporary visas. The order came with a strict 30-day ticking clock. If enacted, it would immediately alter the legal rights of thousands of children. This created an immediate crisis. It tested whether a sitting president could use the stroke of a pen to unilaterally rewrite the rules of citizenship. That 30-day countdown never finished. Lower federal courts quickly stepped in with legal pushback to freeze the policy. In New Hampshire, federal judge Joseph LaPlante issued a preliminary injunction. He blocked the order, noting it clearly contradicted untouched constitutional precedent. However, a prior Supreme Court ruling, known as Trump v. Casa, banned judges from issuing universal injunctions. One judge could no longer block a federal policy nationwide. Without this freeze, babies born in different states faced an indefinite, chaotic legal limbo, dependent on local jurisdictions. To bypass the standard appeals courts and avoid this mess, both the administration and the challengers utilized a rare legal maneuver. They bundled the dispute into a class action lawsuit called Trump v. Barbara. Looking at this photograph of the Supreme Court building, this is exactly where those unique institutional levers sent the case. It rocketed the conflict straight to the highest court to prevent a fractured national citizenship system. During the April 1 oral arguments inside this chamber, the justices narrowed the debate down to 11 specific words in the Constitution. We can see those exact words written here in the original text: born in the United States and subject to the jurisdiction thereof. The Trump administration's defense found a strong voice in Justice Samuel Alito, who ultimately authored the dissenting opinion. Alito argued that the word jurisdiction in this context requires a child to owe allegiance solely to the United States at birth, excluding the children of foreign citizens. The challengers presented a competing interpretation, which Chief Justice John Roberts adopted in his majority opinion. Roberts countered that children born to unlawful or temporary residents clearly satisfy both elements of the clause. They are physically born on U.S. territory, and they are legally bound by American laws while they live there, regardless of foreign allegiance. The entire showdown hinged on this semantic divide, whether jurisdiction demands exclusive political loyalty, or if it simply means being legally subject to the laws of the land. On June 30, 2026, the Supreme Court delivered its final ruling, striking down the executive order. Chief Justice Roberts wrote the conclusive decision, confirming that under the Constitution, these children are citizens at birth. In practice, the 2025 executive order is permanently nullified, protecting the legal status quo for millions of future children. The parchment shown here contains the same 14th Amendment text that has governed American citizenship for over 150 years. By striking down the order, the court confirmed that the requirements for citizenship are set by the Constitution, making them a boundary that a president cannot redraw with an executive order.